start with the case of Tarner versus State. How much time, sir, do you wish to stay for rebuttal?
I don't have a lot to say, so we will, we'll just go with it, Judge. Thank you. May I?
May proceed.
Thank you. William J. Schaefer, Orlando, Florida, 609 East Central Boulevard. Sometimes the drive over here in anticipation of an argument is much longer than the drive back, even if you haven't done well. This is one of these cases. Let me say at the outset, I was not trial counsel in this case. Having said that, the court is aware that this is a case of sexual battery and whether or not there was consent. One of the issues in this particular case is that the complaining witness victim in this case apparently was an alcoholic, suffered from alcoholic blackouts, and to that end, in the record, it is indicated during trial that on prior occasions that she had engaged in voluntary sexual intercourse with the defendant in the case. It was the defense theory, or should have been the defense theory, probably articulated a little more clearly, that during these alcoholic blackouts that in fact one could give consent as she had in the past, and that any of these photographs that depicted the sexual intercourse were in fact probably voluntary and that she consented. Having said that, as an overview of this case, in particular, we have argued that the court should have granted a judgment of acquittal on the sexual battery count. Counsel did not specifically argue that in a motion for judgment of acquittal. I'm well aware of the case law that unless that is fundamental error, that is, that the error reached to the very fabric or heart of this case and disturbed the court's faith in this conviction, that it may not be fundamental error. I believe that I can only argue in good faith that this is fundamental error and that the state failed to prove the necessary element, which was in fact the failure to give consent in this case. The court may say to me, well, the court's probably not going to say anything to me, but the court may think that, well, Schaefer, the defendant, didn't testify in this case, so it's just his theory that that in fact the state did not prove consent. And I have cited the case in the brief that indicates the defendant need not testify to raise that issue. That is just an issue, an element that must be proven beyond and to the exclusion of every reasonable doubt. And we assert it was not proven. However, we do concede that counsel did not articulate that specific argument in his motion for judgment of acquittal. Moving on to point 2, which is probably, again, I would have to go to the end of the argument and concede to the court that counsel failed to object, specifically on the grounds that we've articulated in our brief. The issue in that particular argument is pretty simple. Excuse me. The victim complaining witness testified that her viewing of these photographs that the court has before you is what precipitated her going to the police and prompting the investigation. We know, in fact, however, that the photographs that were placed into evidence could not have been seen by her because, in fact, it was an undeveloped roll of film. The defense proffered the testimony of 2 witnesses that would have testified that she, in fact, had disclosed that she had seen these photographs on a prior occasion, prior to the time that she testified that she saw them, which precipitated her going to the police. It is our position that, excuse me, that certainly would cause a juror to have a little caution in her testimony, and it certainly would not have been a collateral matter to her testimony, and that, in fact, the introduction of the 2 witnesses who The complaining witness victim said, I saw these photographs on an earlier occasion, was not in fact hearsay. It is classic impeachment testimony.
The state argues that that's a collateral matter. What's the significance of the alleged victim having seen the photographs in May or June rather than October?
I think that but for the fact that in this type of case, credibility of the complaining witness is always a central issue in the case for the jury to determine that it would be collateral. Had the defendant testified in this case, I think it would have made our argument stronger that you have the matter of credibility between the complaining witness and the defendant in testifying, but I still believe that this is significant enough to take it out of the category of a collateral impeachment to, in fact, a impeachment on an issue in the particular case.
Do you mean that is what you're talking about, that there was no evidence that she had in fact previously consented? What is it about the defendant's failure to testify that you think is relevant? You just said that if he had testified, it would be stronger. What testimony is it? Is the prior consent the testimony you're referring to, or is it something else?
No, ma'am. It would be the consent issue. And again, one may argue, well, and I've learned a long time now, this trial attorney may have been possessed of facts that I'm not possessed of. But it would seem to me that during the course of this trial, had I not planned to call my client to the stand based upon this court's ruling, I think I probably would have called my client to the stand. I think it then crystallizes and raises what may be a harmless error up to a more a level where it in fact may be more harmful of an error. But again, I can't argue that because it's not here to argue. What I can argue, however, although again the defense failed to object to this, is the state, the court deprived the defendant of first and last in the closing, which I believe was significant because the state, in fact, touched upon and argued the timing of this victim seeing these pictures as bolstering that she must in fact have been raped because she didn't come, the victim didn't come forward until she was absolutely sure that something had happened and she had been raped, and that was in fact engendered by viewing these photographs. The court deprived, I believe, the defendant of first and last wrongly. Perhaps counsel didn't handle the proffer as correctly as one might. That is, from the minute the witness got on the stand, even the perfunctory questions of what is your name, what is your address, did you ever live with the defendant or victim / complaining witness. The court found that since counsel brought that into evidence but was denied the balance of the evidence, that constituted evidence that deprived him of the first and last.
Leave that out for a second, the fact that they didn't object to the sandwich. How would the trial have gone different if the judge had said, okay, you can have these two witnesses testify that this victim knew about these photographs in May or June, not October? Why is that different to the jury on the issue of whether your client should have been found guilty or not?
Your Honor, I think that what could have been argued, and one, I think it would have shut down the state's argument regarding the fact that this victim complaining witness went to the police because she was sure that she had been raped after viewing of the photographs, number one. Number two, I think it would allow the defense to argue, wait a minute, taking the evidence in its totality, I believe that the evidence shows that there was consent. Consent may have been given in an alcoholic blackout, but consent was given nonetheless. And don't forget, the jury failed to convict on the helpless victim aspect of this and convicted him of straight sexual battery. So obviously they didn't believe that she was helpless. The other thing is that, okay, when did she say that she viewed these photographs and what precipitated it? She's going through the box with her new boyfriend. And I believe that had these witnesses been able to testify, they would have testified, wait a minute, she saw these long before, and it's the fact that, oh, a new boyfriend sees something that may upset him that causes her to go to the police and cry foul. The last argument in this, and again, I will have to say that counsel failed to object to the introduction on the photographs as to what we have argued. Again, we're arguing fundamental error on all of these points. This one is kind of a novel issue, I believe, in that we have a citizen seizing what appears to be evidence. Don't know whether it is or not because the roll of film was undeveloped when the victim/complaining witness got it out of the appellant's closet, which they did not share. The appellant, I'll strike that, the victim complaining witness then takes the roll of film to the police, whereupon the police then go and alter the evidence that was given to them by way of developing the film. It is our contention that the alteration of this evidence that clearly belonged to the appellant, that the victim/complaining witness had no right to do, put this in a position of the police altering evidence that was ultimately introduced into trial, and therefore under these unique facts we would suggest that the court ought reverse the conviction. Any other questions?
I've got 3 minutes left.
May it please the court, my name is Chris Davenport and I represent the state of Florida. First of all, let me correct some of the factual issues here. Number one, he was convicted of sexual battery on a physically helpless person. He was acquitted of the digital penetration count, but he was convicted of the penis vaginal contact. We have pictures of this. The victim testified, I looked at this picture, I was not conscious for this, I did not consent to this act. The digital one, she said, I don't know if that's the defendant's hand or not. I can't. She was candid. I can't identify him. The penis, she could identify him. There's enough of his body shown in there that she identified him. That's what he was convicted of. She never admitted that she consented to any prior sexual acts with him. She said she thought of him as a friend and a brother. She never consented to any of this stuff with him. She said that one time she woke up and he was having sex with her and she pushed him off of her. Not I consented to it. It was I got him off as soon as I was aware of what was happening. So that's not what happened either. This roll of film issue, on page 149 of the record, the detective who received the box from the victim said, these exhibits are prints from the negatives. Some of them were prints in the box, and some of them were negatives that they developed in the prints. She's not going to turn over to the police a roll of film that she has no idea what's on it. These were pictures in the box, not a roll of film, so they didn't alter any evidence.
Let me ask you about these two proffered witnesses that the judge said could not testify as far as statements made by the alleged victim. Would you agree or disagree with the trial judge's statement that impeachment is not an exception to the hearsay rule?
I would disagree with that.
Okay. Now, you argued that it was a collateral matter.
Right.
Okay. Now, the state argued this matter in the opening arguments. They argued it in the closing argument, and they argued it in the rebuttal argument that it was a matter that she didn't realize these photographs existed until October, and therefore lending her testimony more credibility. So I guess my question is, if you're arguing that it's collateral, then And why is the state arguing this in its opening statement, its initial closing argument, and its rebuttal argument that it supports the credibility of the victim?
Well, looking at the specific facts in these proffer, that's what makes it collateral. Specifically, the victim testified on cross-examination that she had talked to the defendant's ex-girlfriend and the defendant's mother about pictures. She said she wasn't talking about these pictures. She said he had other pictures he wasn't supposed to have. They never clarified what she was talking about. In proffer of these witnesses, she said pornographic pictures. They said the prosecutor asked if they'd ever seen the pictures. They said no. So we don't even know, and it seems from the record that they weren't even talking about the same pictures.
Well, hadn't she said in her cross-examination that he had photographs of her, but they were not sexual and they were not pornographic, and then the offer testimony was that they were of a sexual nature?
Well, the mother called them pornographic pictures, and the ex-girlfriend called them sexual pictures. Now, the victim testified in proffer that she had taken pictures before of a sexual nature, but not graphic like the pictures in this case. Her fiancé had taken naked pictures of her. She also said vaguely the defendant had pictures of her that he was not supposed to have. From my reading of the record, it looks to me that he somehow got copies of those. She said that she had talked to the ex-girlfriend and the mother about pictures. She said it wasn't these pictures. So given that they never saw the pictures, that the victim said that there were other pictures out there and these weren't the ones she was talking about, I think that makes it a collateral issue. It certainly is harmless error at worst, given that nobody ever saw these pictures that the ex-girlfriend and the mother were talking about. If they had seen them and said, these are the same pictures, we saw them, and she knew about them then, I think it would be a closer case. But they don't even know that we're talking about the same pictures here. So it's clearly a collateral thing. And in collateral matters, they have to take the answer of the victim. And the victim said, yeah, I talked about them, but they weren't the same pictures. So in some ways, it's not even inconsistent, except for the victim said they weren't sexual pictures, and the other witnesses said they were. Clearly, it's harmless error, though. We have a picture of the defendant having intercourse with the victim, and the victim specifically saying, I was not aware of this. If you look at the other pictures that were in that box, she's passed out or unconscious in those pictures. Her head is lowered to the side. She clearly was not aware of what was going on. So I think there's overwhelming evidence of guilt here. Let me just address the opening and closing, the sandwich argument. That's fundamental error, but it has to be preserved below. And trial counsel never objected below. He never said that he should get the opening and closing, and he shouldn't have because he called a witness. If we're going to start judging whether or not the witness was a good witness or had enough testimony to give up the sandwich, this is going to be a really difficult rule to apply. As it is now, it's black and white. If you call a witness, that's it. You lose your right to the sandwich, and it should stay black and white, or we're going to be dealing with this issue all the time. So if the court has no other questions, we'd ask that you affirm.
You said it was fundamental error, but it has to be preserved below.
Yep, I misspoke. It can't be harmless error. I misspoke. You're right. It's not a fundamental error, but it can't be harmless, but it still has to be preserved. Thank you.
Any rebuttal?
Just let me say that she is absolutely right. I did mistake. He was convicted of a sexual battery, a helpless victim. I misspoke. I apologize to the court for that. Regarding these photographs, again, perhaps the proffer could have been made a little clearer as to what photographs that the defense was seeking to have these witnesses testify to. But I believe if you take the testimony of the proffered witnesses in their entirety, that in fact it reaches an inescapable conclusion that everyone was referring to the photographs that were in the evidence. Why in the world would you seek to put a witness on a stand to rebut something that wasn't in evidence if they were talking about other photographs? And that's about it. Thank you very much. I'll see you in a half an hour.